The Supreme Court refused just before midnight on Wednesday to block a Texas law prohibiting most abortions, less than a day after it took effect and became the most restrictive abortion measure in the nation. The vote was 5-4, with Chief Justice John G. Roberts Jr. joining the court as 3 liberal members in dissent. The majority opinion was unsigned and consisted of a single long paragraph. It said the abortion providers who had challenged the law in an emergency application to the court had not made their case in the face of complex and novel procedural questions. The majority stressed that it was not ruling on the constitutionality of the Texas law and did not mean to limit procedurally proper challenges to it. But the ruling was certain to fuel the hopes of abortion opponents and fears of abortion rights advocates as the court takes up a separate case in its new term this fall to decide whether Roe v. Wade, the landmark 1973 decision establishing a constitutional right to the procedure, should be overruled. It also left Texas abortion providers turning away patients as they scrambled to comply with the law, which prohibits abortions after roughly 6 weeks. All 4 dissenting justices filed opinions. The court's order is stunning, Justice Sonia Sotomayor wrote in her dissent. Presented with an application to enjoin a flagrantly unconstitutional law engineered to prohibit women from exercising their constitutional rights and evade judicial scrutiny, a majority of justices have opted to bury their heads in the sand. The court has rewarded the state's effort to delay federal review of a plainly unconstitutional statute, enacted in disregard of the court's precedents, through procedural entanglements of the state's own creation, Justice Sotomayor wrote. The court should not be so content to ignore its constitutional obligations to protect not only the rights of women, but also the sanctity of its precedents and of the rule of law. Chief Justice Roberts wrote that he would have blocked the law while appeals moved forward. The statutory scheme before the court is not only unusual, but unprecedented, he wrote. The legislature has imposed a prohibition on abortions after roughly 6 weeks, and then essentially delegated enforcement of that prohibition to the populace at large. The desired consequence appears to be to insulate the state from responsibility for implementing and enforcing the regulatory regime. The Chief Justice underscored the tentative nature of the majority's ruling. Although the court denies the applicant's request for emergency relief today, he wrote, the court's order is emphatic in making clear that it cannot be understood as sustaining the constitutionality of the law at issue.